Starting the second half of the first day of this conference. It's again great to be here again and to see many familiar faces. This panel is dedicated to the human rights dimensions of information conflicts. This is something we've already alluded to a bit earlier today when we did, I think, identify both in the presentations, but also in some of the Q&A, the links that exist between the topic that we are discussing here, the information conflict domain, and many of the domestic challenges that we are encountering in the area of misinformation and disinformation. And this is a field in which international law and international human rights law has been already engaged with in the last few years. And our thinking when we organized the conference would be that it would be perhaps interesting relatively early on to introduce some of these questions and put them on the table. And we have a wonderful cast of panelists to walk us through those issues from a variety of angles. I will introduce them each as they speak. Before I do that, I might note a couple of interesting and important developments that could impact this discussion as well. One is it has already been alluded to that the Pact for the Future has been adopted at the UN earlier this week, and that pact also has an annex which is called the Global Digital Compact that tries to identify some common strategies and common approaches in the realm of international relations and technology. The Global Digital Compact, it's of course a non-binding document. It's not a treaty, but it could be a focal point for future activities, legislative efforts, maybe enforcement efforts on the part of the UN and other actors. I will note that one of the objectives that the Global Digital Compact identifies is to foster an inclusive, open, safe, and secure digital space that respects, protects, and promotes human rights. So there is this idea that any policies that are developed at the international level in the digital domain would have to be human rights friendly. There are then 13 principles that the Compact identifies, and one of which is that the Compact is anchored in international law, including international human rights law. All human rights, including civil, political, economic, social, and cultural rights and fundamental freedoms, must be respected, protected, and promoted online and offline. Our cooperation will harness digital technologies to advance all human rights. So there is this general commitment to promote, protect human rights while developing policies in this field. And specifically, there is a paragraph which I thought I would flag in the compact that talks about information integrity. So this is the framing in which the Compact deals with the topic that we are discussing. And it does contain a number of potentially significant policy points. One is that manipulation of online information is a threat to human rights. Two, that there is a specific challenge in this domain in the area of hate speech. The paragraph on information integrity also contains a commitment to promote digital literacy, to diversify information ecosystems, to promote access to science-based counter-information, especially in crisis situations, and also to encourage the UN to engage in impact assessment on how disinformation and misinformation affects the sustainable development goals. It contains some recommendations, including a call, and this was mentioned before, a call on digital companies to empower users to make informed choices regarding digital services, including recommendation algorithms, and call on companies to develop evidence-based strategies for dealing with misinformation and disinformation and AI-generated content. So this is an approach which pushes some of the responsibility in the field towards companies. I would say that although we can discuss whether this is the right approach, it is not completely divorced from the approaches was taken by the EU in the Digital Services Act that entered into force recently, that does require what are called the VLOPs, the very large online platforms, to conduct risk assessment and to adopt risk mitigation measures, including in areas relating to disinformation and misinformation that could harm electoral processes and disrupt civil societies. So this is one area where I think we are seeing a little bit of movement towards identifying disinformation as misinformation as a human rights issue at the global level, and developing some certain frameworks for addressing this issue, which also includes a human rights dimension. The second contextual factor, which I would very briefly indicate, and this is something we've also been discussing last year in the conference, and that is that the world of human rights is often confronted with great difficulty, issues relating to information operations by reason of the jurisdictional limits of human rights law. As those of you who are working in the field know very well, human rights law, international human rights law norms typically apply within the jurisdiction of the state, and that has traditionally been understood to focus mostly on the borders of the state, and hence a cross-border operation might, according to this traditional approach, not be covered by a human right obligation. That is, if the Russians are disrupting the US elections under a traditional understanding of the scope of application of human rights law, it would be questionable whether Russia would be engaged in a violation of the right to take part in government of the citizens of the United States. But this is something which is changing, and there have been in a number of areas in international human rights law, and this is something Laura will be discussing later, there has been a movement towards a more functional approach towards jurisdiction, which puts greater emphasis on the degree in which the state in question controls the ability of individuals to enjoy their rights. And at least the Human Rights Committee has in the past taken the position that where you have an act or omission that results in a direct and reasonably foreseeable impact on the ability to enjoy rights, this might be covered by the relevant treaties. There has been a development in this regard in the European Court of Human Rights, which until recently has been probably the most reluctant international body to jump on the bandwagon of functional jurisdiction. And we do have a case from late 2023 called Wieder and Garnieri versus UK that does deal with the UK surveillance policy, which is not our topic of this discussion, but it does take the approach that once the UK big data and mass surveillance program seizes data of a US citizen and an Italian citizen who haven't set foot in the UK, the very fact that they have gotten access to their data would be enough to bring those individuals within the scope of the European Convention, and it did find violations of the rights of these two individuals by the United Kingdom. So it's not a full endorsement of the functional model, and the court actually does not really enter into a very detailed discussion as to why it is doing what it is doing. But I at least, have been working and writing on this, identify here a certain crack in the wall that the court has placed around extraterritorial jurisdiction. So these are some initial ideas, and now we move on to, like I said, a very interesting and impressive set of speakers. Our first speaker is Dr. Irene Couzigou, who is a professor of international law at the Law School of the University of Aberdeen in Scotland. She teaches there general and specialized courses in international law for undergraduate, postgraduate students. She also conducts research in a variety of international law fields, including, broadly speaking, on peace and security, but she's currently focusing mostly on cybersecurity and international law. And she would, in that area, she analyzes how states, but also powerful non-state actors could cooperate to better secure cyberspace. She has degrees from Paris 2, and she also is following closely French public law. And indeed, in that context, she will be speaking about how French law in particular has tackled or is engaged in the fight against manipulation of information, addressing misleading and false information spread online during particularly election campaigns, which is something that is also quite relevant to what's happening here in the rundown to the upcoming November elections. So without further ado, Irene, you have the floor.
Well, thank you. So I will focus on a particular law that was adopted in France in 2018, exactly on the fight against the manipulation of information. And I will try to take lessons from this law that could be applied in other states, including in the United States. So the electoral campaign that led to the election of the President of the Republic in 2017 was targeted by a disinformation campaign. And this disinformation campaign wanted to harm candidates, in particular Emmanuel Macron, who was a front runner in that election. So emails from Macron's close collaborators were hacked and disseminated on Twitter under the name Macron Leaks in approximately 47,000 tweets and very quickly to many people. This operation occurred only 2 days before the first round of the presidential election. But nevertheless, this did not harm too much Emmanuel Macron because, as you know, he was finally elected as the President of the Republic. But this cyber operation annoyed Macron, who, once President of the Republic, wanted to have a law that targeted the manipulation of information. And this when disinformation is disseminated before important elections in electoral campaigns. So there are actually two laws, an ordinary law and an organic law. The organic law simply repeats the content of the ordinary law concerning the election of the President of the Republic. So I will simply focus on the ordinary law of December 2018. Both laws have been deferred to the Constitutional Council, that is the French Supreme Court. And the Constitutional Council declared those laws compatible with the French Constitution, however, subject to certain reservations related to their interpretation. So the Constitutional Council narrowed down the scope of both laws in order to respect the right to freedom of expression. So France, of course, is bound by the right to freedom of expression because it is a party to several human rights treaties, but also because the right to freedom of expression has, under national law, a constitutional value, meaning that all other laws have to respect the right to freedom of expression among other constitutional human rights. So what are the means adopted by the legislation against manipulation of information. There are three means. First, there is a role given to online platforms to prevent the impact of and react to disinformation. So important online platforms do have obligations for transparency during the 3 months before general elections or referendums. So the laws against manipulation of information apply only to important elections, meaning to national elections, for instance, the election of the President of the Republic, or the elections of the members of parliament, or the elections of the representatives of friends sitting in the European Parliament. And the legislation also applies to referendums, so to direct national elections. So large online platforms must provide their users with information about the identity of the natural or legal person who sponsors information of general interest, presenting a link with an electoral campaign. Why? Because it is thought that if the users are aware of the origin or of the sponsoring of certain information disseminated online, they will be more critical towards this information. For instance, if users are aware that information from a particular political party concerning a particular political party was sponsored by this party, well, maybe the users will not trust too much this information or be a bit critical towards it, at least. Furthermore, online platforms do have to inform the users about the remuneration of information disseminated online if this remuneration reaches a certain level. Again, to show that maybe this information is not to be trusted as it is, because sponsored by a particular entity. The French legislation was amended recently to take into account the Digital Service Act that was mentioned a few minutes ago, because under the DSA of the European Union, very large online platforms and very large search engines also have responsibilities in the fight against disinformation. First, they have the obligation to assess the systemic risks arising from the design, operation, and use of their services, as well as from the potential misuse of services by recipients of services. And under the DSA, one systemic risk is constituted by the possible negative effects on civic discourse and electoral processes. If the systemic risks are discovered, there is an obligation of very important online platforms and search engines to address those systemic risks, however, taking into account fundamental rights, including the right to freedom of expression. So one way to address disinformation disseminated before important elections would be, for instance, to alert users about false information. So that would be a responsibility of the online platforms. But it is up to the online platforms to do whatever it seems to be fit to address electoral disinformation. The second means adopted by the law against the manipulation of information is to give to an independent authority the power to counter foreign media that disseminate false information. So here, this provision in the law was included, again, following the will of President Macron, who, when he was running for his first mandate as French President of the Republic, was upset by the disinformation disseminated by Russian state-funded outlets, news outlets, namely RT and Sputnik. So once President of the Republic, he gave new powers to the regulatory authority for audiovisual and digital communication, that is the French Broadcasting Regulatory Authority. And following those powers, the Regulatory Authority for Audiovisual and Digital Communication can suspend or interrupt or prevent authorization to broadcast to radio or television services controlled by or influenced by a foreign state. However, the Constitutional Council here limited the scope of the powers of the regulatory authority. Indeed, the Regulatory Authority for Audiovisual and Digital Communication can suspend or interrupt the broadcast of the sole information that is incorrect or misleading for voters and for which falseness can be objectively demonstrated. So this understanding of the information that can be targeted by the regulatory authority was imposed by the Constitutional Council. So you can see that only certain information can be addressed by the regulatory authority. Furthermore, the regulatory authority can suspend the broadcast of online communication services only during 3 months before the elections or the referendums. Okay, so in any case, as you can see, there is legal limit of what the Regulatory Authority for Audiovisual and Digital Communication can do, mostly because of the need to respect the right to freedom of expression. We may also think of political limits because the authority may be reluctant to suspend or interrupt the broadcast of foreign news outlets for political reasons. And indeed, the regulatory authority has by now never suspended or interrupted the broadcast of news outlets. However, the European Union did, because the European Union in 2022 suspended the broadcast in the EU of RT and Sputnik. And this, of course, also in France. And finally, the third means to address this information is the creation of a new judge, so a new judge sitting for urgent matters, who may prescribe to online public communication services any measure to halt the dissemination of inaccurate or misleading allegations or imputations of facts likely to alter the honesty of elections. And this only during 3 months before the relevant elections or referendums. However, here too, there are limits to what this judge can do. Indeed, in accordance with the law, the judge for urgent matters can be seized during the 3 months only, as I said, before general elections or referendums, and the judge has only 48 hours to rule. So you may wonder, okay, but in 48 hours, it will not be possible to any judge to assess whether an information is false, misleading, or not. But in reality, it may be possible because following the decision of the Constitutional Council, the new interlocutory proceedings can relate to only certain digital information, namely digital information whose falseness can be objectively demonstrated, whose incorrect or misleading nature is manifest, and which have an evident risk of altering the honesty of upcoming elections. Furthermore, the dissemination of that information must be deliberate, artificial, or automatic, and massively transmitted by an online communication service. So those are many limits. So at the end of the day, it will be almost impossible for a judge to order the suspension of the dissemination of any information. But this limit has to be respected following the ruling of the Constitutional Council. So to summarize, so there are 3 means adopted under French law to address digital disinformation. So to give some responsibilities to online platforms, but of course online platforms cannot be asked to monitor what they store or disseminate because they are not responsible under French law or under the Digital Service Act for the information that is disseminated online. And I think they should not be asked to control online content because then there is a risk that they may not respect the right to freedom of expression. I mean, they are, I think, obliged to respect this right, but there is a risk given that they are a private company that they will not do so. So I don't think that too many responsibilities should be given to online platform to delete or suspend information. However, they could maybe make information more transparent, so inform users more about their origin. The second means adopted by French law is to give to an authority the power to cease the broadcast of foreign news outlets. I think that's a good solution, but to a certain extent, because under our democracies, at least the right to freedom of expression should still continue to be respected. And there is a need for pluralism of information. And finally, the third means adopted under French law was to give to a judge the power to order to online platforms the taking down of online content. But here, as we saw it, the judge can do so only regarding certain limited information. So honestly, I think that law is a bit powerless to address digital disinformation if the right to freedom of expression is to be respected at the same time. So I think instead of reacting to digital disinformation that is already online, it is probably necessary to try to limit the impact of that disinformation on the users. That could be done with given to online platforms more obligations towards transparency, the transparency of what is that disseminate. Online platforms could also develop fact-checking processes. And furthermore, in general, users should get a more critical mind towards what they see online. So information and media literacy should be developed. So in France, well, we are just at the beginning. In the United States, information and media literacy may be more developed. I would be happy to hear about it. But the solution would be probably to trust users more, so to empower users of online platforms. So thank you for your attention.
Thank you very much, Irene, for presenting questions in the end to everyone. It will be unwieldy if we'll start now the Q&A. But it was a very interesting presentation. Thank you. And it's also, I mean, I find it quite remarkable how the way the different strands that we talked about this morning, the domestic and the foreign disinformation are actually tackled with one fell swoop. I mean, with one law that actually potentially could address both. So the next speaker is Laura Dickinson, who's right here in the center, and she's the Lyle T. Alverson Professor of Law at the George Washington University Law School. Not traveling very far today, but we are extremely grateful for you being here. Laura focuses on a variety of national security, human rights, and law of armed conflict issues, including the foreign affairs privatization. In addition to her scholarly work, Laura has served in government. She was special counsel to the General Counsel of the Department of Defense 2016-2017, and received a Secretary of Defense Medal for exceptional public service. She also served as senior policy advisor to Harold Koh when he was Assistant Secretary of State. And she will be speaking today about how international human rights law might apply to extraterritorial cyber operations within and outside armed conflicts.
Thank you, Yuval, for that kind introduction. It's really wonderful to be here as part of this event. So I am going to make 3 relatively big picture points. The first is that human rights are highly relevant to state-sponsored information operations, in particular extraterritorial state-sponsored information operations. The second is that the human rights paradigm faces some significant hurdles in regulating state conduct. And third, in my view, the human rights paradigm is not a straitjacket. Okay, so the first point, that human rights are highly relevant. So extraterritorial information operations by states have the potential to implicate many, many human rights. As we've heard from the wonderful presentation, the right to freedom of expression, the related right to freedom of assembly and freedom of association, the right to privacy, the right that's understood to be the right to free and fair elections, and many, many more. Now, if we take the example of state information operations and how they might affect the right to free and fair elections, you could see how this could happen directly if a state deliberately tries to hinder people from participating in voting by tampering, using information to sort of tamper with election machines, or to send out false information about where a voting booth might be, but also can do so more directly by kind of spreading disinformation and misinformation about political rallies, false political rallies, trying to get people to go to those rallies, false information about candidates, and so forth. And we've heard some examples from France. This could have an impact on people's right, not just to participate in free and fair elections, but right to free speech. Why? Because the right to speak, the right to free speech is understood to be the right to speak, but also the right to receive information. Certainly in international human rights law, it's understood that way, but also the right to engage in freedom of association and assembly. And if people's confidential information is being leaked and disclosed, as for example, was the case when Russia hacked into the Democratic National Committee email and released that information to the public, that could be seen as a violation of the right to privacy. These rights are protected in global human rights treaties, such as the International Covenant on Civil and Political Rights, and also in regional human rights treaties, such as the European Convention on Human Rights and Fundamental Freedoms, and also the Inter-American Convention on Human Rights and the African Charter on Human and People's Rights. But it should also be noted, as was mentioned in the previous talk, that information operations to combat mis and disinformation also run the risk of running afoul of human rights. So, for example, there was a concern about over restrictions on speech in the name of protecting against misinformation and disinformation, actually harming people's right to speak. And so the French court limited the scope of that French legislation for that reason. Okay. Well, I want to turn now to the fact that the human rights paradigm faces some pretty significant hurdles in regulating state conduct. And The first hurdle is jurisdictional. And it's the issue that Yuval mentioned, that there is a challenge and a debate about the extent to which a state's extraterritorial operations are governed by human rights obligations. Do they apply at all? And there's a debate among states about this. Now, the Human Rights Committee, as Yuval has said, and Yuval has literally written the book on this issue, the Human Rights Committee has sort of moved in the direction of a functional test for when the state's obligations kick in, when they're acting extraterritorially, and it has to do with degree of control. That's a vast oversimplification, but I think it's helpful to think about it in this way. The European Court of Human Rights has really flip-flopped on this issue. It's hard to pull out a coherent doctrinal test from the European Court's jurisprudence. Though, for example, in the Bankovich case, where this wasn't information operations, but countries that were party to the Council of the Convention on Europe, the European Convention on Human Rights, Council of Europe countries, they conducted an airstrike outside the territory of Europe, outside the territory of the Council of Europe countries in the former Yugoslavia, and the court said that's outside the jurisdiction of the convention. That action cannot be considered by the court. But in other cases, particularly involving detention, military detention, for example, by Council of Europe countries in Iraq, the European Court has said that that is subject to the court's jurisdiction because of essentially this control that is being exercised by governmental authorities, European governmental authorities outside the Council of Europe. And then we have this wonderful, interesting recent case that Yuval described. But there is an ongoing debate about this, and the United States has continued to assert that in most circumstances, its human rights obligations do not apply outside the United States. I think we can have a debate about where the trend is going. I think most experts would say that it's going towards extraterritorial obligations, and the United States is kind of on the other side of this. But we can have a debate about that and a discussion about that in the Q&A if people want to. So extraterritoriality is a challenge. Another challenge is weak enforcement mechanisms. And I know that we have some representatives here who've played an important role on these enforcement mechanisms, but they are pretty weak in the human rights area. So with respect to the global human rights treaties, they are mostly enforced, and enforcement may be a word that is too strong to use even with respect to these human rights treaties. They are mostly monitored. States' compliance is monitored by treaty bodies whose authority derives from the treaty itself. And they conduct periodic reviews of countries' compliance. For some countries who've opted in, there are complaints processes that are possible, individual complaints. And then, of course, they issue important general comments on the scope and nature of the rights, such as the Human Rights Committee's interpretation of extraterritoriality of obligations under the ICCPR that Yuval mentioned. And of course, we have wonderful special rapporteurs, such as the role that Kaye played for many years, writing reports on the extent to which states are following their obligations under various treaties and treaty provisions in different thematic areas and with respect to particular countries. So, you have a lot of jurisprudence being generated, but the enforcement mechanisms are relatively weak at the global level. And then at the regional level, we have 3 regional human rights systems. The European system, which is the strongest for Council of Europe countries. We also have the American system. That system is weaker because not all countries in the Americas are party to the Inter-American Convention on Human Rights and therefore subject to the jurisdiction of the Inter-American Court. And then we have the nascent African system of human rights that flows from the African Charter on Human and People's Rights, which sets forth the human rights norms, and the court there, which is developing a jurisprudence, but most commentators consider it to be relatively weak. So at the end of the day, the human rights system is pretty weak. A few other challenges to the human rights system. Let's say the extraterritorial operations are in armed conflict. We have very complex questions about whether human rights law applies in armed conflict, with some states arguing that human rights obligations are mostly displaced during armed conflict, and others saying, no, they're not displaced, but they might be limited in terms of how they should be interpreted. So we have a long-standing debate there. And then we also have the issue of state actors, non-state actors. Non-state actors are not directly governed by human rights law, unlike the law of armed conflict, which binds everyone to follow its norms and rules. Human rights law does not directly bind non-state actors. So if you're thinking about social media companies, they are not directly bound under human rights law. States have an obligation to ensure respect for human rights by non-state actors. And so in various courts and tribunals, that's one way that non-state actors have been brought within the fold, but mostly the obligations of non-state actors and their role has been addressed through soft law norms, soft law statements of responsibility, best practice that are not technically binding, but set forth important normative guidance. 1 minute, okay. Okay, so the human rights system faces a lot of challenges in its ability to be enforced, and that is something that I think we need to discuss in the Q&A. But I want to turn to my last point, which is that I do not think that human rights obligations are actually a straitjacket. Human rights norms, such as
time is up.
Big expression.
Human rights norms are often, in the way that they're written in the global human rights treaties and the regional human rights treaties, subject to some limitations. Obviously, they have to be necessary and in accordance with law, but some restrictions can be permitted, for example, for national security reasons or other reasons. There is also the option of derogation in the time of emergency or war. And what I want to emphasize here, and by the way, the rights that we're talking about, privacy, free speech, these are derogable rights, unlike torture and the right to life, which are non-derogable. I also just want to go back to the way the rights are drafted. And if we use the example of free speech and free expression in the international system, this right is crafted as the right to speak and also the right to hear. This is actually quite different from how it's conceived in the United States, which is it's more absolutist. and in our First Amendment. And our court, the US Supreme Court, has taken a more absolutist view than, for example, Europe. And it's interesting hearing you talk about what I sense is frustration with the French approach. But the French approach actually allows for some flexibility because it allows for mandates on social media companies, even though they've been clawed back a bit. There is room to regulate them. And I think that reflects actually more flexibility in the content of the right. And it gives some room for information operations. And the same, I think, would be true with respect to privacy, which we can define it in multiple different ways. And there are ways to protect privacy while also perhaps limiting privacy at the same time.
Thank you. Thank you very much, Laura. Now I have been cut off. So that was again very, very interesting. Anecdotally, the Dankovic case you mentioned was also about shutting down a TV station, but through a bit more aggressive means than a EU edict on RT and Sputnik. And the other thing I wanted to point, of course, and that goes without saying in this discussion, but once all of these decisions and approaches have a massive spillover effect. So, for instance, Israel, if you've watched the news this week, has shut down Al Jazeera, which is a Middle Eastern TV station, and they have shut it down in Israel and now also in the West Bank. And they're, of course, citing the example of the EU shutting down RT and Sputnik as the justification for shutting down what they regard to as a fake news outlet. So all of these, so we have to somewhat be careful what we wish in these domains. Our next speaker is David Kaye, who has already been introduced a little bit by Laura, and I'm sure many of you, all of you, or many of you know David. David is a professor of law at the University of California at Irvine. He is the former UN rapporteur for freedom of opinion and expression. He served in that capacity between 2014 and 2020, and was very notable in his activities, especially on all things digital. And apropos writing the book, he did actually write a book on these issues called Speech Police, the global struggle to govern the internet, which is highly recommended. David is also the serving member at the Venice Commission, which is the European Commission for Democracy Through Law, which the US participates in. And he also has some government background. He did serve in the State Department as a lawyer in the 1990s and beyond. And he is currently also, I should note, at the independent board chair of the Global Network Initiative and a trustee with Article 19, which is a major freedom of expression organization. And in the spirit of extraterritorialism that is crossing boundaries, we are now going to cross the border between our panel and the next panel. And David is going to discuss some of the human rights aspects of the new Convention Against Cybercrime. It will be discussed, the convention, more comprehensively in the next panel. But we are going to, in a way, give you some appetizer in this panel, and David will address some of the human rights concerns with this treaty, especially regarding safeguards and the definition of cybercrime.
Thanks, Yuval, and thanks to everybody. Thanks to the organizers for including me in this conference. It's true. I originally intended to speak about the cybercrime treaty, and this is a lesson that I need to learn for myself. I saw that there was an entire panel on the topic. So I'm taking personal lessons from that. But I also, I don't want to spend all of my time on the cybercrime treaty. Actually, what I want to do even though I want to touch on it, I want to put it in context of this panel's focus on information operations, information in conflict, of course, and I want to make sure that my remarks speak to my co-panelists' interventions as well. So in the next few minutes, I want to emphasize first a few points that are actually going to piggyback off of a bit of Laura's presentation and talk about the structure of international human rights laws, protection of the right to freedom of expression, protections that I believe are relevant to our panel's discussion, and then I'll turn to the cybercrime treaty's risks, but not at any granular level, but really to talk a little bit about what I think it shows about the current geopolitical conflicts that we're facing, about how law applies in the first place in a context of widespread attacks on the information and communications ecosystem. Okay, so first, I really don't want to be pedantic or super basic about this, but I do want to start with the fundamental protections that are provided in human rights law for freedom of expression. So the global protection, as has already been alluded to, is found in Article 19 of the International Covenant on Civil and Political Rights. It guarantees everyone's right to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, and through any media of one's choice. And this is basic, but I want to take it apart and to sort of take it apart starting from where Laura left off, which is, I think it's really important at least in taking that language apart, first to notice that seek, receive, and impart, as Laura identified. It's not just about the speaker, right? It's also about those who are seeking and receiving information. But there's three other elements that I think are really useful as we think about the robustness of this right. And I'm ramping up the robustness, not only because I was a special rapporteur, so I'm supposed to embrace this right, but also because I think we in part need to evaluate the restrictions in light of the robust statement of the right. And that goes to what's available to states to restrict freedom of expression. So the other elements are information and ideas of all kinds. That's a pretty strong statement, full categorical statement about what freedom of expression means, what expression applies to. It's also regardless of frontiers, which is obviously relevant to the subject we're talking about now, which can mean any number of things, but at the very basic level, it must mean that I, in the United States, have the right to receive information, at least under Article 19.2, the definition, the right to receive information that's coming from, say, Russia or anywhere else, and that Russians have the right to receive information from me as well. I mean, let's not forget that. And then, of course, it's through any media of one's choice. I think of that sort of set of elements as being almost perfectly drafted for the digital age. The right to seek, receive, and impart is like, the right to search, download, and post. It's very much speaking to the moment in which we live. And I think that right is really quite robust. Okay, so then, of course, again, as Laura indicated, the right is followed by a restriction. It's actually followed by what I think of as a little bit of throat clearing. Individuals have duties and responsibilities. I could live without that language, but it serves as a chapeau for what follows, which is the recognition of state authority to limit the exercise of freedom of expression, so long as the limitation meets the three-part test of legality, necessity and proportionality, and legitimacy. What do those things mean? The legality part provided by law is the language prescribed by law in the European Convention. Obviously, it means that the restriction must be in pre-existing law, but it also must be clear and precise. It doesn't give the state, excessive discretion to determine what falls on either side of the permitted and unpermitted line. Necessity and proportionality, well, we could have like several weeks of conference on what necessity and proportionality mean, but at the very least, it's the least intrusive means. It's designed to meet the assessed, the asserted threat. Legitimacy, again, national security and public order could be one, but also the rights and reputations of others, public health or public morals. Now, I start with this framework, which I imagine most, if not all of you are pretty well familiar with, because I think it gives us a clear guide as to how we might think not only about information operations, which themselves might be considered on their own to be interferences with access to information, but also about efforts to counter information operations, again, as my two previous co-panelists indicated. And so a number of questions arise from it. What guardrails does human rights law impose upon the state's adoption of tools to counter disinformation or propaganda? Probably don't want to leave Scott off the map here, but he's going to address, I think, the propaganda for war side at the end. How should we understand the legality principle in the context of efforts to address an adversary's information operations? What should be the standards for assessing the proportionality of such state actions? And here, if, as Matthias Kuhn and Stephen Garbaum have really emphasized, that proportionality is also an effort at public reasoning, how do we get to the public reasoning when so much information that might underlie a state's decision to take action against information operations is actually classified? And so that public debate, or at least the public demonstration of what might be the basis for any restriction, might be limited in that environment. And that's a human rights law problem, frankly. But it is a part of how we think about, or how we might think about, freedom of expression. So turning to the cybercrime convention, I'll limit myself to a reaction really at a higher level of generality, since the next panel, I think, is going to really get into the meat of it. So the law enforcement demand for international cooperation to suppress cybercrime is completely understandable. How that cooperation operationalizes has been a feature of international debate for, at least 30 years, right? Since the rise of the digital age, we've talked about this fundamental question about what digital cooperation means. We have a lot of law to look to. We have a lot of dispute, a lot of jurisprudence around this. But the demand for cybercrime cooperation, I think, when it's among democracies, it takes on a different valence when it's made by countries like Russia and China. And no doubt, really no doubt, the law enforcement authorities in the United States, in Canada, in Europe, those who participated in the cybercrime negotiations understand this point extremely well, and they've been in the trenches on this, again, for decades. But here I would focus on a high-level concern in the cybercrime draft, or the cybercrime convention, that stems from my own experience in observing both China and Russia seek to undermine long-developed, well-established interpretations of the freedom of expression, of peaceful protest, of privacy, and other fundamental rights. And these are efforts that are continuing, I think, at a geopolitical level, if we want to put it that way, in the UN Human Rights Council every single session, and in the course of the negotiations that you've all mentioned at the outset over the Global Digital Compact. And the Russian delegation made a very striking comment this morning about the Global Digital Compact that hopefully will get widely seen, because it really demonstrates the geopolitical nature of this information debate. So the Cybercrime Convention includes, I think, far too much that suggests to me problems under the legality principle of the three-part test. So I'm just going to focus on one issue, and that's the draft's repeated reference to serious crimes. I put that in quotes. Serious crimes is a term of art in the convention. It remains substantively undefined. The treaty in draft defines the term as involving, quote, conduct constituting an offense punishable by a maximum deprivation of liberty of at least 4 years or a more serious penalty, end quote. So now the convention does suggest some guardrails to prevent abuse of this term, but I find those guardrails pretty unpersuasive. And if I were a reporter subject to the serious crime of defaming the Russian military, for example, or covering a disfavored topic, such as the government's extraterritorial counterterrorism actions, I wouldn't find the guardrails all that reassuring. Instead, I see this term, among others, as offering a normative acknowledgement that the seriousness of online crimes may have little to do with legitimacy of criminalizing such behavior. And to me, that's a problem. It may seem like the proverbial camel's nose under the tent, but I think it's a serious normative move on its own, and it will, if the treaty enters into force, I think, cause all manner of pressure on states to cooperate when it comes to legal demands. So will the United States? I would hope not, but I'm also not really sure. This is my little timer, but I have a minute. I did it a minute early. I still have a minute too. The mic is still on, exactly. I'm not getting cut off. So, will the United States succumb to that pressure? I doubt it, but also I don't know what U.S. governance is going to look like in the next several years. I don't think any of us can be certain of that. Many others lack rule of law standards and the ability to stand up to pressure and may readily bow to it. So I'd be concerned. I'm concerned about this language in part because of the normative framing that it is injecting into the international environment, or at least reinforcing, let's say, in the international environment. I would also add, and I'll conclude in just a second, that it's not only governments about which we should be concerned. The convention will likely put significant pressure on companies, those especially that retain subscriber or other personal data, to share that information with governments that demand it. In rule of law societies, again, they should be able to resist, but not always. And outside of those places where rule of law prevails, when the government demands, for example, a local presence combined with a normative pressure of a cybercrime convention system, corporate ability to resist that will be severely tested. So, in short, as Yuval stands up, human rights law helps us understand the nature of the threat and the nature of response to threats. And I'm looking forward to the Q&A that should follow.
Thank you. Thank you, David. And again, thank the panelists for introducing one another. So you've already acknowledged Scott, and you've also offered a preview for the next panel. So it's all flowing very smoothly. Thank you all. Our next speaker is Scott Sullivan, last but not least on this panel, who's a professor at the U.S. Military Academy at West Point, with appointments at the Army Cyber Institute and the Department of Law. His research focuses on the intersection of emerging technology and cybersecurity with international and U.S. foreign relations law. Before joining West Point, Scott held a professorship at Louisiana State University, LSU, and was even before that he was a lawyer at law firms in New York and Chicago, and worked on issues relating to the UN, but also to the US and the EU, specifically on issues relating to sanction compliance and counterterrorism. And he will be speaking with us, as David indicated, about the prohibition of war propaganda as constructive and affirmative obligation on states to intervene in order to protect the public, and how that obligation might give rise to the use of active measures, including cyber operations, in order to short-circuit propaganda dissemination. So you have the floor, Scott.
Thank you. It's a pleasure to be here with such distinguished panelists. As a matter of fact, as this was unfolding, I was thinking if this was a relay race and Yuval was the coach and he put me at anchor, he would get fired. But I realized that we were just all victims of the alphabet, I suppose. So that's how I got here. But I will say that I do like to think that what I'm talking about does follow pretty nicely David's talk regarding Article 19, because I'm going to be focusing a little bit on Article 20 of the International Covenant on Civil and Political Rights, and thinking about the prohibition on war propaganda that exists there. So Article 20 tells us that any propaganda of war is to be prohibited under the ICCPR. And in thinking about this prohibition, right, that any propaganda for war is prohibited by law, I've thought about a couple of questions that I think are interesting questions, one of which is about the scope of the prohibition. So, we don't have a lot of language there, right? And so where does this prohibition begin and end, right? When do states have to prohibit it? and when do they not? And the second is about thinking of affirmative obligations where states are the victims of propaganda being perpetrated by other states, and what affirmative obligations they have to stop the production and or distribution of war propaganda under this provision of Article 20. So there are a lot of questions that I think relate to this that I'm not going to be talking about, but I do think that advancement on this question does provide something useful. So this was a side issue in the RT France versus Council of the EU, in which RT France was taken off of the air, but that was decided under EU law, not specifically under the ICCPR. Now, what we've seen instead is that this prohibition on war propaganda is largely considered a relic of the Cold War era. It was pushed by the Soviet Union. There was a lot of actual Western resistance to it, and we've instead seen focus on the second part of Article 20 regarding incitement towards hostility, and Article 19 set out in relationship to the specific provisions as to other types of limitations in relationship to national security. And I think that because of that, we see the underdevelopment of the prohibition on war propaganda. So Irene, the Special Rapporteur on Promotion and Protection of Right to Freedom of Opinion and Expression, in her 2022 report, mentioned that propaganda is, quote, is mentioned but not defined in international law, and that while disinformation seeks to confuse and disrupt, the objective of propaganda is to advance a particular agenda or party. But both are considered information operations. As it relates to the ICCPR's prohibition on war propaganda, she notes two limitations on its scope. One of which is that it's applicable only in relationship to a war of aggression or breach of the peace, contrary to the UN Charter. And the second is that it's limited to the incitement of war and not to propaganda that's perpetrated during the war. Now, as it relates to this first limitation, I think that that is by far the best reading. I'm not going to focus on that, but we can talk about it more if you like. But the second question, I think, is a little bit more unclear to me. This idea that this war propaganda limitation is only for incitement to war. Now, the basis for that understanding comes out of the Human Rights Committee's prior judgments that speak on it briefly, and certain state communications, and some drafting history that is what it is, but I will say I don't find overwhelming. The other aspect of it is this inherent linking of Article 19 and Article 20, right? That essentially whatever limitations you have on the right to expression through Article 20 have to fulfill the same standards and be strictly limited as to Article 19. Now, I'm not sure that that's right. I think there's some reasons to question this relationship. So one reason is that war propaganda is narrower than national security or public order. So in Article 19, if those are the bases that you can limit speech, right? But later on, we say that war propaganda has to be prohibited by law. It is substantively more limited, and you might think that that substantive limitation is not by accident, that it is at the heart of some particular ill that we're trying to resolve. It's also obviously a separate article that's articulating that speech of that genre, war propaganda, must be regulated, not may be regulated, right? So it shows that there is some particular prerogative. Now, I don't think that that's particularly shocking given the post-World War II era and thinking about what is at the heart of the concern in our UN system of international security. But there's also an affirmative argument that's worth making for a broader understanding of that scope. So one of which is a textual argument. So Article 20, right, and this war propaganda says any propaganda for war, right, must be prohibited. Any is, awful broad, right? Like it's not saying some, it doesn't even just say war propaganda, it is any, which suggests a more expansive reading of that language. Plus Article 22, right, the other prohibition regarding incitement to hostility or violence, talks about incitement, right? So it says incitement to this hostility must be prohibited. We don't see that same language, and obviously it's not because the drafters didn't know how to use it. Now, there's, I think, also this kind of normative argument that is part of it, which is to say, international security is the North Star, I think, of understanding a lot of our post-World War II system of human rights. And the idea of trying to create circumstances conducive for a lasting peace, right, is something where we should always err towards that end. And I think that a prohibition of war propaganda during a conflict is just as useful towards that end as avoiding incitement. Also, I think there's something about the idea that incitement in relationship to war propaganda makes less sense because the actual harm is unfolding when a war of aggression is occurring. So we often think of something like incitement as needed, right? When that harm may be speculative. But now, when you don't have the speculative harm because the aggressive war is in fact continuing, cutting off that war propaganda seems consistent with the purpose of the act. The other aspect I wanted to talk about briefly is just about affirmative obligations. I think that one of the things we've talked about is Laura talked about quite eloquently is about the limitations that we have as a system and in fact effectuating some of these human rights. And that is unmistakably the case. And no one expects Russia to stop, for example, engaging in war propaganda. But the idea that a state possesses an affirmative obligation, right, and perhaps affirmative powers to intervene, to reach in fact, cut off that war propaganda when its population is being exposed to it, is, I think, a strong argument as well. Now, the idea that a state possesses some authority through the human rights regime or an obligation, right, to intervene doesn't mean that there are not limitations to that intervention that I don't have time to speak to, right? Other aspects of law do preclude what a state can do lawfully, right, in relationship to ensuring the protection of the human rights of its people, and those would remain valid. But I think that if we think doctrinally, the idea that a state has an affirmative obligation to prohibit the continuing spread of war propaganda within its jurisdiction is in some ways easy, right? We can say that as it relates to the question of due diligence, right, and avoiding transnational harm, that's obvious as it relates to trying to protect its citizens in relationship to the other host of human rights that both Irene and Laura talked about being affected, I think is also clear. But I also wanted to say that I think that understanding an affirmative obligation for states to intervene and cut off war propaganda within their jurisdiction is consistent with a few other normally good benefits that are worth considering. One of which is that an expanded scope of a state's right to intervene discourages propaganda perpetrators, even when they're not legally covered. And I think that to that extent, we could say that we know that Russia is not the only perpetrator, and that the idea of getting greater clarity on this question would be valuable. In that sense, number two, it helps define the boundaries of norms and terms that we think require more clarity. So as I said, the special rapporteurs noted that this is an area that is underdeveloped. More legal dialogue as states act and intervene and justify their actions and interventions will help clarify terms like propaganda as legal terms rather than just as colloquial usages. And it also might help in relationship to assisting private entities. So a lot of discussion about social media companies and what they should or should not do. A lot of social media companies crib from the development of law, right? And providing greater clarity in relationship to these norms will help moderation efforts by private entities. And then finally, I think that we can say that an affirmative obligation tied to war propaganda empowers states domestically to intervene with core problematic speech, giving them a specific vehicle towards, I think, an aspect of speech that we find most troubling and most threatening to our larger human rights system.
Thank you very much. Thank you very much. So I want to thank all four panelists for excellent contributions. We have just over 10 minutes, which is not a lot of time. So what we will do, we'll collect a few questions. Please be attentive. And then I will ask maybe in reverse order to address whatever questions they would wish to address. You're not required to address everything. Yes, please. Start with it.
Thank you very much. Professor Irene, this question is for you. My name is Babak Eklagi. I'm a faculty member at the University of Maryland. You mentioned on one of your slides that there is the law state there must be a link between the user that posts and information relating to a campaign. Social media have to disclose the source. I'm sorry, I paraphrase. I forgot the exact text. But the social media have to disclose the source. What is the definition of a link? Because as a user, I could say something that is a personal opinion that could relate to a campaign. I could have a limited influence versus a social influencer that has million followers. What does it mean to be, what does that definition of, is there a definition for a link in the, okay.
Thank you, Jonathan.
Yeah, questions for Scott on the war propaganda discussion. I'm curious as to what you see as any linkages to the conversation about extraterritorial application of human rights law, in particular because traditionally you might think that the propaganda prohibition was directed at states not imposing propaganda on its own population. And yet in today's environment, we think about it as much more a extraterritorial threat of a state imposing propaganda that might be directed at another state's population. And curious what you know about the history of that and how we would interpret it today in a more global environment where propaganda is thought of as crossing international borders.
Thank you, Svetlana.
Thank you. My question is also on the question of war propaganda and the scope of affirmative obligations. Very often, those who actually do engage in such behavior are those who have immunities under domestic law. And I was wondering about the connection between criminalization obligations and immunities of, say, MPs. Thank you.
Thank you, Kobo.
Yes, Paul Kubomaczak from the University. I have a question for Laura. You won't be surprised, but thanks to all the four panelists on the panel. I was struck, by your observation that armed conflict is a topic that you chose for your presentation. I was just wondering if you could elaborate a little bit on it. What I jotted down was that some states are arguing that human rights obligations are misplaced in armed conflict. Correctly. I would say that there is only one state that I know of, that's Israel, that says that international human rights law does not apply in situations of armed conflict. For all other states, they accept continued rights. So, and the question is, how does it apply, and what is the linkage with international humanitarian? So, my question is really, where do you see the gap when it comes to information operations that you might observe in situations of armed conflict? Even if we say, okay, in some situations, humanitarian law might prevail over a conflicting human rights law, fine. So that we could accept. But what kind of protection gap does that leave? Even in RHL, we have specific rules that protect against information. Think about the prohibition of encouragement of violations of RHL, referable back to Convention 1. Think about the protection to respect and protect medical and humanitarian facilities, which protect against information operations against them. Think about lots of others.
There are a lot of things we can think about. I'm thinking about both.
Where's the protection gap? Even if we said, okay, in some situations, IHL might prevail.
We'll take three more, and that's it. James,
That's okay.
Sean, and
That's all right. That's all right.
you'll pass. Okay,
I'll pass.
two then, Sean.
A question for Irene about the French law. What is the nature of the service provider's duty to investigate who's really behind it? Do they just need to pass along what they think they know about the person that's posting it? Or do they have to dig a little deeper? Do they owe some diligence in figuring out who's behind disinformation or misinformation about an election?
Thank you.
I know we have 1 minute for questions, so
I'm going to tweet my question and hopefully get a Twitter answer. This is mostly for Professor Kaye, but anybody else who has a Twitter answer could help. When I was in the Clinton White House, went to a lot of international negotiations, and we had a positive agenda. About 15 years ago, the US government got into a defensive crouch, and it was all about preventing bad things from happening. If you were in charge of the US proposals for these various discussions, what's your headline? What would you be pushing for that would actually be a positive contribution to the discussion?
Super. So now there are actually questions to all panelists. So that's also, thank you, audience, for your constructive engagement. Scott, we start with you.
Sure. So these are both good questions.
We still have limited time, so please, 1 to 2 minutes per answer.
So look, I think that yes, in some ways, the West's concern about the war propaganda was that it was going to be used to regulate speech that would be kind of designed to limit internal dissent, right? To crush internal dissent. But even the idea of incitement contemplates international action, right? Because the idea is that as the special rapporteur had said, is that it's about incitement towards a war of aggression, right? So like against the violation of the UN Charter, right? So it's contemplating international action there. So I think that there is more weight that more states were comfortable with the prohibition insofar as it related to international action. So I think that in some ways that's consistent with kind of the arguments that I was pushing. I think that there are one of the many questions that that I think are left unanswered, right? Like from these views that I articulated is sort of in what ways can the state, right, like regulate war propaganda? And does that include things like criminal prohibitions? And I think that it becomes more difficult to justify, right, the further and the heavier the punishment is. So if we're talking about this idea of the use of this kind of regulatory power to, in fact, then impose criminal punishment on individuals who lack, right, the immunities, right, or haven't, right? Like, I think that is an unanswered question, but my gut reaction is to essentially say that to be consistent with sort of the norms as I set out, you probably wouldn't be talking about as much criminal prohibitions as much as sort of active intervention to preclude the spread and distribution of the underlying propaganda. But I have limited time, I understand.
That's right. Yeah, I mean, the Article 20 does talk about legal prohibition, and the question of enforcement, you could argue, is dealt with elsewhere. David?
I thought we were going in order.
Correctly, that was the...
oh, yeah, you're going reverse. I got it.
Reverse order.
Yeah, no, I understand. Not reverse order of seating. No, absolutely. I won't take very long. Just to respond to the question about sort of what's a positive agenda look like. I mean, I have my wish list. Don't we all have our wish list of what the United States would do out in the world? I mean, I would mention just a couple of things. I mean, one, I think we've just for too long treated human rights as a foreign policy rather than domestic policy, and that interferes with our ability to develop actually domestic jurisprudence that can then be, in a way, exported because ours comes in a constitutional context that is a little bit different. I think we should, for example, establish a national human rights institution to find ways to bring these into the fore. But I also think that U.S. engagement at the international level has generally been, I mean, certainly over the last 3.5 years, has been pretty positive. And the one area where we see that, where the U.S. is a leading force, is in the commercial spyware industry, where the U.S. approach has been really forward-leaning and has focused on human rights, but also national security harms that are caused by commercial spyware. So I think there's actually some good examples from the last few years that I would like to see more expanded upon.
Yeah, the US also stood behind the Safe AI resolution at the GA, which was also an interesting position. Laura?
Great. Thank you for that great question. And so thank you for that great question. And yes, the reason why I would say, well, an armed conflict situation is an obstacle to the enforcement of full human rights goes to this point about states adopting this view of lex specialis. So it's true that states who adopt this do not necessarily say that all of human rights law is displaced by all of IHL. But this is an important view that many states have. The United States doesn't even really get to it because of its views on extraterritoriality, non-extraterritoriality of most human rights obligations in most circumstances. But as you well know, and as many of you well know, the thing about the armed conflict setting is that the condition of war is often interpreted as a time of derogation that would allow for pulling back on rights obligations. And let's take examples like free speech or privacy. So to the extent that they would even apply, there would be a condition of derogation probably, or in many situations. Most people, and it is interesting though, with respect to lex specialis, most people would say that LOAC IHL does not actually include a right to privacy or a right to free speech. So if it doesn't, then it would give scope for these rights to apply if they apply extraterritorially. But again, you have this condition of derogation in time of war. I will just say, though, in the book that I edited with the West Point Lieber series, Big Data and Armed Conflict, Fionnuala Elaine, who is the Special Rapporteur for Counterterrorism, she said, which really surprised me, that when states were sort of given the choice to be in the armed conflict paradigm or the human rights paradigm, states that wanted to get around law, they much preferred to be in the human rights paradigm than in the armed conflict paradigm, because they saw that as a much more constraining paradigm than the human rights paradigm.
Thank you. Finalement, Irene.
So thank you for the good questions. So what does it mean to have a link with an electoral campaign? So it's not defined by the Constitutional Council. So in the French law, it was sufficient for the information to have a link with a question of a general interest, what was even vaguer, but the Constitutional Council narrowed it down to a link with an electoral campaign, whatever that means. So it is for the online platforms to interpret it, but I have to say that the online platforms are monitored by the Regulatory Authority for Audiovisual and Digital Communications when implementing the French law. So they have to report about what they do. And concerning what is the meaning of being controlled or influenced, so when is a news outlet control or influence, so it is also not defined by the French law. But the French law had in mind, of course, RT and Sputnik. But in 2021, a new service was created in France called the Service for Vigilance and Protection Against Foreign Interference. So that service that works for the government to discover foreign interference online, and this service works very closely with the Regulatory Authority for Audiovisual and Digital Communications that is independent. So.
Thank you very much, and thanks again for the 4 panelists. Thank you for your attention and your excellent questions. And now the gift bearers for the medalists.